All right. Good evening, everyone. Thank you for joining this webinar. Tonight, we will hear from Elissa Taub, immigration lawyer and partner at Sisk & Susser for the webinar H-1Bs, the good, the bad, the alternatives. I look forward to introducing Elissa in just a few moments. Please note tonight's presentation will be recorded. While everyone's still logging on, I want to take a moment to introduce myself. My name is Ashley Pichard. I am the Manager of Program Relations here at PracticeMatch. Hopefully, since you're here tonight, you already know about PracticeMatch and all that we have to offer physicians. If not, I want to highlight a few of the resources my team and I have available to you to make sure that you get the most out of your PracticeMatch experience. We have a free CV builder and free expert CV review. We have scholarships. We'll actually be adding several new scholarships this year. I'm really excited about it. So make sure you're checking back later this spring. Those should be live on our website May 1st. We also have a job board where you can see job postings. You can filter them by specialty, geographic location, visa status, and more. You can create a profile with us and fill in your preferences. That way we can notify you about jobs that come open that match what you're looking for. We also have virtual career fairs to connect you with employers hiring in your specialty. You can earn some additional revenue during training for attending them, and you can earn even more additional revenue by becoming a physician ambassador and encouraging your colleagues to attend. So if you're a social person, you like to do that, you're committed to your job search, I recommend applying for our physician ambassador program. I'm happy to share that we're also bringing back live career fairs this year. I'm so excited about it. Those are going to be live on our website by the end of the week if you would like to find us in a city near you. In fact, you can meet our presenter, Elissa, if you are able to attend in Nashville or Chicago. She will be there with us. We have free monthly webinars on various topics regarding training. So you've got your interview preparation, contract negotiation, immigration assistance, loan repayment, and more. These are free to physicians. So if you find the content interesting, we hope you attend our webinars. If you think that your program would benefit from a personalized webinar on any of the topics that I mentioned above, we can do that too. So just reach out to me. We have a free physician immigration handbook that is provided by Sisk & Susser. We're happy to have one of the authors as our presenter this evening, and we actually have this book available for download now. So once Elissa introduces herself, I will put the link in that chat box. If you want to go ahead and download your free copy, that will be available to you. We also have a network of experts in just about every physician-facing industry as well. So if you ever have a question related to career guidance, you can definitely reach out to PracticeMatch and we'll be happy to provide you with mentorship and guidance or connect you with someone who's an expert on that topic. Now, let's learn more about physician immigration. Please note that microphones will be muted throughout the presentation. If you have any general questions, Elissa will try to cover those in her presentation. Please feel free to put those in the chat box so she can kind of see what you're looking for. If there's anything that doesn't get answered here, or if you have a question that is personal or specific to you, Elissa will share her contact information at the end of her presentation. That way you can reach out to her. So Elissa Taub is a partner in the immigration law firm Sisk & Susser, where she leads the firm's healthcare immigration practice. She handles numerous matters for physicians, including J-1 waivers, H-1Bs, and green card applications. Elissa is the co-author of the Physician Immigration Handbook that I just mentioned. She's also an active member of the American Immigration Lawyers Association and has served on many national committees. She's a leader within the American Health Law Association, and Elissa earned her law degree from Villanova University School of Law and her bachelor's degree from Washington University in St. Louis. Welcome, Elissa.
Thanks, Ashley. And it's great to be here with you all tonight. And I'm as excited as one could be to tackle the topic of H-1Bs. So I will we'll dive into the subject matter in just a minute, but I just want to give a few quick housekeeping pieces of advice. The first thing is that, yeah, I'm a lawyer, of course, but in this type of setting, because this is not a confidential setting, I would ask you to not necessarily ask like really personal legal questions in the Q&A. The better thing is to ask general questions in the Q&A. I'm happy to always have you schedule a consultation with myself or with any of my colleagues. And you can do that by going to our website, and I'll provide my contact information on our website information at the end of the webinar. And as I mentioned, you can put questions in the Q&A at any point during tonight's program, and I will endeavor to answer those as I go through. If I see that there's something you've asked that I'm going to cover later in the presentation, I'll answer it at that point. But if it's something that's really, hyper relevant to the issue I'm covering at the time, I'd love to tackle your question in real time. So please feel free to use the chat. And I will, like I said, I'll monitor that as we go. And so without further ado, tonight we are going to talk about H-1Bs. And as I mentioned, the good, the bad, and the alternatives. We don't want to say that they're ugly, but the alternatives sometimes can be pretty good. But, it's March, it's H-1B season, and we'll talk more about why that is in a few slides. And I thought that this would be a particularly relevant topic for us to tackle tonight, as we may have folks on this webinar who are in H-1B status and looking for their first post-training job, or folks who may be looking for the ability to lateral transfer from one H-1B employer to another. This is a really important topic, and maybe doesn't get covered in the in connection with physicians the same way that J1s do. So I think it's a good idea to take a little bit of a deep dive on the topic tonight. So one of the best things to do when we start talking about a topic is to go back to the basics, the fundamentals, and say, well, what is H-1B status? So many physicians are on H-1Bs, and I bet most of y'all have never really thought about, well, what exactly are the basic requirements of this status? H-1B status is available to somebody who's coming to the United States temporarily to work in an occupation that is known as a specialty occupation. I've put the definition of specialty occupation on this screen. Essentially, what we're talking about is a professional position that requires at least a bachelor's degree or higher level degree in a specific field or fields in order for you to be qualified for it, right? So doctors are, a great example of an occupation that is quintessentially eligible for H-1B sponsorship. You guys don't just need bachelor's degrees, but you need advanced degrees, medical degrees to qualify. So we usually don't have trouble showing that a physician is qualified for H-1B status. That's usually a given. Sometimes the Immigration Service will issue some kind of silly request for evidence saying, you filed this H-1B for a general internal medicine physician. Since this is a general position, please show that it requires at least a bachelor's degree in a specific field. And we write back and we're like, the person's a doctor, right? This position is for a doctor. And we get our point across without being too rude, and those cases always get approved. But there are, those are the basics, right? So we know that physicians qualify for H-1Bs, but there are a lot of other tricky requirements that you need to navigate if you're in H-1B status and you're looking, for employment, and you're trying to figure out, can a particular employer sponsor me? Am I eligible to be sponsored for that job? So one of the very first things, and you see in the very first bullet point, it says, for someone to work for a U.S. employer. You cannot sponsor yourself for an H-1B as an individual. You need to have an employer in the United States to sponsor you for that H-1B. The employer is going to be your sponsor, or we call them the petitioner of the H-1B, and you are the beneficiary. This gives your employer a lot of control and power over that H-1B process, and they have a lot of legal requirements and hoops to jump through in order to sponsor you. But that's the power dynamic for the H-1B category. The employer is the sponsor, and you, the beneficiary, must be a W-2 employee in order to be eligible. The Immigration Service is pretty clear that they do not see an employer-employee relationship where there's an independent contractor relationship. And so for that reason, you really do have to be a W-2 employee in order to qualify. This is the reason why you don't really see a lot of H-1Bs in the locum world. There are plenty of physicians that would love to do locum work and plenty of locum agencies that would love to hire you, but they can't sponsor you as an independent contractor. Occasionally, what we see is a physician might set up their own practice, and that practice will sponsor them for a position, and then the practice will contract for that locum work. We don't see it that frequently because again, it's kind of complicated to go through all of those steps, but that is, a workaround for somebody who might want to do locum work on a, pretty robust basis. So those are some of the basics of H-1B. But there are 3 critical issues that you need to navigate as you go through H-1B sponsorship. The prevailing wage requirement, which for most doctors isn't a huge deal, but it's something that you should know about. The 6-year maximum stay, and then of course, the evil H-1B cap. And this time of year, we immigration lawyers particularly think it's evil because it makes us work all kinds of crazy hours filing H-1B registrations. So we'll talk about that in a few slides. The prevailing wage requirement is a very interesting one. It was created by Congress to, try to prevent American employers from hiring H-1B employees at a lower wage rate than they hire their Americans, right? There's this fallacy that international employees get paid less than American employees. So the prevailing wage requirement was instituted to try to prevent that. And what it says is that you as the H-1B employee have to be paid either the higher of the prevailing wage for that occupation in the area where you're going to work, or the actual wage of what folks working for your employer in the same occupation with similar education, training, and experience are being paid. The prevailing wage is usually on the lower side for physicians. When we go online, usually the highest prevailing wage I might see is $208,000 a year across all the specialties. Sometimes we see a little bit higher than that, but that's really on the higher side. Most of you were probably like, wow, that's not very high. And it's not compared to a lot of the physician wages that we see. But the actual wage that your employer is paying to other physicians in the same occupation for, folks coming out of the same kind of training programs might be twice that. And then the government is going to expect you to be compensated, in the same way that American workers are being compensated or that other folks at your employer are being compensated. I have on the screen here how you look up a prevailing wage. And before I kind of explain this to you, what I want to tell you is that your immigration lawyer, the individual who's, handling the filing of that H-1B, we're going to look up the prevailing wage. We're going to put that all the places it needs to go in your application. We're going to talk to your employer if your offered compensation does not equal or exceed the prevailing wage, and we're going to tell them they have to raise your pay. So we're going to take care of all of that as far as the immigration process is concerned. It's not something that you really have to worry about doing. But I also think that it's helpful to know where we're getting this information when it goes into your application. And that the first place we put the prevailing wage is on the labor condition application, or LCA, which is the first step in a filing for an H-1B. So we go into the online wage library. The Department of Labor publishes all of its prevailing wages at that website you see on the screen, www.flcdatacenter.com. And when you go to that website, in the middle of the page, you see the screenshot that I put there where it says online wage library. And you see a choice of 4 things. And I bet you can't guess which is the one I click on almost every day. It's that line there in red that says FLC Wage Search Wizard. When you click on that, you go to the next page. You can choose your state, and then you get to choose either your county or your city, depending on how your state is organized. And then once you do that, it gives you the ability to choose your occupation. All of the healthcare occupations start with the number 29, and it goes 29 dash, and then there's a code that comes after that. All of the physician occupations that are separately listed in the online wage library, I have listed on this slide. We didn't always have such specificity. There used to be many fewer choices, but last year they revamped the process and revamped the offerings. And so now we have a lot more to choose from. But you may be looking at this and you're thinking, well, my specialty isn't separately listed there. How do we find out my prevailing wage? And you will notice that in quotations, I have physicians all other and surgeons all other. Those are the categories that we use when there's a specialty that isn't separately listed. So if you're a urologist, we're going to look under physicians all other, right? Because urologists is not a separately listed specialty. If you are, you know, a neurologic surgeon, we're going to look under surgeons all other because neurologic surgeons are not separately listed in the online wage library. And what that means is that under those all other categories, the wages are kind of aggregated and they tend to be depressed then, right? Like they're looking at averages across a lot of specialties. And so the wages tend to be lower than you might other see. So that's what the prevailing wage does. That's how we look it up. And it's a really important part of the H-1B process, not just for when we file it, but, as you go through working in H-1B status, your employer is required to pay you the wage that they say they're going to pay you in your H-1B petition. And of course, that wage can't be lower than the prevailing wage. So there's a whole, everything's kind of related when it comes to that. So that's the prevailing wage issue. Critical issue number 2 is this darn 6-year limit. The basics of H-1B status are that you can only hold H-1B status for 6 years. You can initially be granted that status for 3 years, and then it can be extended for another 3 years, and then that's it. You've hit your max. However, there are 2 big picture ways to get beyond that 6-year limit in some way, shape, or form. And there may be some of you on this webinar tonight that are already in that situation. You're like, I know all about this. But for those of you who are not there yet, one way to get an extension beyond the 6-year limit is through getting to certain milestones in the green card process, and the other is through recapturing time. When it comes to the green card process, you can see that there is a difference between being eligible for a 1-year extension and being eligible for a 3-year extension. Anybody can be eligible for a 1-year, basically like a 7th year extension of your H-1B, if your employer has either sponsored you for a perm labor certification at least 1 year prior to the end of your 6th year, or if you or they have filed an I-140 at least 1 year prior to the end of your 6th year. And I know I'm veering off into green card speak, and we don't have capacity tonight to really dive into what those things are, but they are milestones in green card sponsorship. The thing about these 1-year extensions, as I mentioned, anybody can get those regardless of where you are from in the world. However, the government wants to make sure that if you're pursuing a green card, that as soon as you're really eligible to finish that application and finalize applying for the green card, that you do it expeditiously. So if you have a current priority date and you're otherwise eligible to file an I-485 application, within 1 year of you becoming eligible and having a current priority date, you must file that I-485 or you lose the ability to get subsequent 1-year extensions. I have a client right now, just to kind of give you an idea how this works. He is nearing we're getting him an 8th year extension now. We filed his I-485 within the year of when he became current. It's kind of a long story about why we had to wait that long to file for him. But because we filed within that year, we are able to get him not just one 1-year extension, but we just are getting him a second one. So we're able to kind of continue that on. For folks who are from backlogged countries, so India and China, right now are the 2 for physicians, the 2 countries that have, significant backlogs. You are eligible for a 3-year extension under those same. You can get a 1-year extension, under that rubric I just mentioned. But if you have an I-140 approved at any time, you're eligible for a 3-year extension. And what's interesting is I've been in situations where somebody was really, getting on toward the end of their H-1B time by the time we were even able to start a green card process for them, because they used so much H-1B time during their training that, they didn't have an employer to sponsor them, and they kind of didn't realize about green card sponsorship until like the end of year 5, right? So there was no way for us to file anything a year ahead. The processing times were long enough that we didn't have an I-140 approved by the end of that person's 6 years. And so we've had a few situations over the years where somebody left the United States until that I-140 was approved. And we were even still able to then get them another 3 years. Once that I-140 approval came in, we were able to file. So you don't, having that gap didn't prevent them from being able to get that extension the way we were supposed to. We don't want to be in that position, but sometimes those kinds of cases are unavoidable. The last option is what I mentioned before, which is recapture time. Because you're only allowed to be in H-1B status for 6 years, the government did something actually kind of nice. They said, well, we want you to get the benefit of every single day of those 6 years. Well, when you're not present in the United States, you do not hold a U.S. immigration status. I know that that seems weird, right? Because your identity, you kind of think, well, I'm in H-1B status. But when you're in Canada or you're in the UK or you're in India or somewhere else, you're not in the United States. So you're actually not in any kind of status here at that time. So what the government said is, you know what, we'll allow you to recapture those days that you spent outside the United States over the course of your 6 years of H-1B time, and you can tack them on to the end. Typically, we do this, when the person is nearing the end of their 6 years and, we don't have a green card in hand yet, or the ability to get a 1 or 3 year extension. We'll say, you know what, or maybe we can only get a 1 year extension, but we have some recapture time. And we say, okay, how long have you spent outside the United States? Last year, we filed one for just 9 days. And those 9 days were really, really important for that physician. One time I had a physician who was able to recapture 180 days or thereabouts, which was hugely impactful, right? Sometimes any amount of time you can get can really bridge some gaps for us. So, over the course of your H-1B status, it's a good idea to kind of keep an eye on time that you spent outside the United States, because even a few weeks could be impactful if you need it. Now, if you're already eligible for 3 year extensions, you're never going to recapture time because you can only get a max of 3 years on an H-1B extension. So the recapture doesn't really matter for you. But if you're in one of these in-between situations where you really need the time, recapturing can be really, really beneficial. So that's the 6 year limit. It's certainly something to plan for. And I should have mentioned, with all of this green card wrangling, it's one of the reasons why I strongly recommend to my employer clients and my physician clients that we start green card processing no later than the end of your 4th year of H-1B time. That usually gets us enough, we can usually get through enough at that point to at least have a perm filed by the end of year 5, to potentially have an I-140 by that time. Maybe if you're not from a backlogged country, maybe to even have you a green card by the end of year 6. There are really good reasons to start green card processing by the end of year 4. Now, if you're doing a long-term fellowship and you're not going to finish that till the end of year 5, there may be self-sponsorship options that you can look at to put, to kind of put yourself ahead of the game with regard to those 6 years. Or you may be able to talk with employers way ahead of time and see if you may be able to work out having them sponsor you before you step foot in the door. There are, good strategies that we can employ ahead of time with good planning. So I think if you're somebody who's planning on doing subspecialty training in H-1B status, it's really, really important to start planning your green card process as early as possible so that you're maybe not running up against the 6 year limit in an emergency. Not always possible. I don't want to make it sound like it's easy, but it's way better to kind of keep your head up and see what's right in front of you rather than kind of put your head in the sand and say, oh, I'll just deal with it later, which is something we all like to do. So let's move past the 6 year limit and talk about the H-1B cap, because this time of year, this is really what comes up in my practice and for most immigration lawyers who work with employer-based immigration. The H-1B cap is really the hot topic. What is it? The H-1B cap is an annual nationwide limit on the number of H-1Bs that the government can issue. The max is 85,000, and that's made up of 65,000 H-1Bs for anybody who qualifies, and an additional 20,000 that are under the master's cap. And the master's cap is available for folks who have a master's or higher level degree from a U.S. institution. Now, for physicians who went to medical school abroad and have not obtained any sort of master's or medical degree or higher level degree beyond a bachelor's in the U.S., you go into the 65,000 pool. If you did a higher level degree here in the United States, like maybe a master's in public health or something like that, then you would get a bite at the master's cap. And the reason why this is important is that folks who can apply in the master's cap, that lottery gets run first, and then they get put back into the general cap to get a second bite at it. So if you're eligible for the master's cap, you get run through the lottery twice, essentially. But if you're in the general cap, you only get run through once, which is, it can be pretty frustrating. And I should also mention that doing a residency or fellowship in the United States does not count as an advanced degree. So that does not get you into the master's cap because it's not a degree. The government looks at it as training. So that's really a non-starter with regard to master's cap qualification. Every year since about 2014, immediately the government, as soon as the cap opens, the government gets more than 85,000 applications. To the point where this past year in 2022, they received 400,000 registrations, or a little over that, for the 85,000 slots. I became a lawyer because I don't like to do math, so I will leave that up to y'all to kind of figure out what those odds are, but they're not great. I filed 4 cap cases last year. 1 person got picked, and that was like amazing. And the reason I do so few of them is because physicians, unlike many folks, have a lot of cap exempt opportunities. We'll talk about that on the next slide. And employers of physicians and physicians themselves tend to be kind of risk averse. So we don't see a lot of doctors putting themselves in the cap lottery. But it does happen every year. We do, a few. Our general business immigration practice does many, many more for folks in the IT industry or, fashion, all kinds of things, right? Any industry. Those folks are doing a ton of cap registrations. So what does the government do, right? I'm talking about registrations and a lottery. The government runs a lottery to determine who can be considered under the cap and who's in excess of it. It used to be before 2020 or 2019 that we actually had to fully prepare all of our H-1B cap submissions and FedEx them off to the government and hope they got there within the first 5 days of April and, hope for the best. And it would take months for the government to go through all of those submissions and mail us receipts. There was times I wouldn't find out until June if my client was picked. I mean, it was really ridiculous. In 2020, they started an electronic filing process where we register folks for the lottery. The government conducts the lottery electronically, and then there's a filing period for us to submit our actual petitions. So this year, we are currently in the lottery registration period. It started on March 1st, and it goes through noon Eastern on March 17th. Those dates will fluctuate annually, and the government will run the lottery by March 31st. There have been some years they've done it on the 29th, on the 30th. They don't tell us. All we know is that all of a sudden we get emails telling us to check our accounts online. If you're selected, your employer is going to file your petition between April 1st and June 30th. I will tell you, filing on April 1st is not common because in order to be able to file on April 1st, your employer would have had to have already prepared most of the application while you're waiting to find out if you were selected in the lottery. And that's sort of a waste of resources with the odds being so bad. So most immigration lawyers aren't going to spend a lot of time doing all the paperwork to prepare an H-1B petition, not knowing if it's going to be picked in the lottery, right? Because, your employer doesn't want to pay for that. So typically, we'll file, into late April or early May, just depending on the situation. But we've got 3 months to file. Once approved, your start date can only be October 1st. There is no way to get an H-1B cap lottery number before or after that. And the reason is the cap numbers, those 85,000 visas, are available on the federal fiscal year, which starts on October 1st. So if I were to file an H-1B cap lottery or cap petition now, it would get rejected in the mailroom. The Immigration Service would say, you can't file this. There aren't any cap numbers available. The only day that those become available is October 1st, which is why the lottery and the filing season open up now, because the earliest we can apply is 180 days before your start date. So that's why the first date that you can file H-1Bs is April 1st, and they run the lottery in advance of that. A lottery submission, I should mention, is not a visa application. It's not an H-1B petition. If you don't get picked in the lottery, it's not a denial. It's not a black mark on your record. It doesn't impact your ability to go for visa stamping, none of that. It literally is like buying a lottery ticket, buying the Powerball and seeing if you won, $500 million, which would be really nice, but like not everybody wins $500 million. So that's the way the lottery works. And as I mentioned, in healthcare, we do not do a lot of these filings just because there are a lot of other options available. Namely, there are opportunities that are exempt from that cap, and we refer to that as H-1B cap exemption. So for employers or work sites that are exempt from the H-1B cap, we don't have to go through the lottery. You can have a start date that's anytime during the year, but we have to show that we meet the requirements of cap exemption. As I just alluded to, you can work on a cap exempt H-1B if your employer qualifies as a sponsoring institution. That's called employed by, right? You're employed by the entity that's exempt, or where you work at an institution that qualifies. That's called employed at cap exemption because you're working at the location that qualifies. A great example of that is in the staffing industry. I do a lot of work for hospitalists and emergency medicine physicians and anesthesiologists who all work for a staffing or management company that employs them to work at a particular hospital. And we are able to benefit from the same cap exemption as the hospital itself, even though the staffing company is for profit and it wouldn't otherwise qualify on its own. I should mention as an aside that doctors who receive J-1 waivers based on working in an underserved area are personally exempt, so none of this would apply to them. But if you are a J-1 doctor who gets a hardship waiver or a persecution waiver, or if you never had a J-1 and you've been on H-1B status since you came to the United States, and it's always been cap exempt, right? Through your residency or fellowship program, you're probably on a cap exempt H-1B right now. When you go to look for your post-training job, you're either going to deal with the cap lottery if you go work for a regular private practice or for-profit employer, or you're going to be looking for a cap exempt opportunity. The cap exempt institutions I've listed there, 1, 2, 3, institutions of higher education, nonprofit organizations or entities that are related to or affiliated with an institution of higher education, which I will come back to in a moment, and nonprofit or governmental research organizations. Of those 3, the number 2 is the most common. Most physicians aren't employed directly by a university or college to be eligible for the first type of cap exemption. It does happen, not as common. But that second prong is all your nonprofit teaching hospitals that have academic affiliations with whatever medical school that's out there, or nonprofit hospitals that may have an affiliation with a nursing school or something like that. There are some really important keys to know about this. It has to be both nonprofit and academically affiliated. One or the other won't cut it. So just being a nonprofit hospital doesn't work. Being a for-profit hospital that has a residency program in-house doesn't work. There actually has to be some relationship with an institution of higher education. How do we prove that? Well, initially we prove that by providing the affiliation agreement, that formal written agreement between the hospital and the school. So they have to be willing and able and to sharing that with whoever is filing that H-1B petition. That is a key piece of evidence. It's really important. And we also need to show that relationship is for the purpose of education and research, or education or research, and that it's active and ongoing. So not just an agreement on paper, not just a business agreement or some commercial agreement, but it really has to be an educational or research-related affiliation, and we have to prove that they're using it. Now, we do that sometimes just through a letter from the hospital or the school or both. We can do that by showing, hey, here's a list of all the doctors who are residents at this hospital through this affiliation this year, right? Like there's lots of different ways to prove that. But, becoming eligible for CAP exemption is more than just ticking some boxes and saying, and me saying, hey, it qualifies, believe us, this is all good. The government's not going to believe us. They want to see the actual objective proof that the relationship qualifies. So that's really important. Now, if the employer is University of Memphis, and that's an institute, a nonprofit or public institution of higher education, all we really have to do is show that and show that they qualify as an institution of higher education, and we're good. It's really that second prong that is, that's really requires a lot of deep work between your immigration attorney and the employer to make sure that all of the keys are met. All right, so that's H-1B CAP exemption. And I kind of raced through that. I feel like I raced through that a little bit, but it's a really, really important aspect of H-1B sponsorship, especially for physicians who do have a lot of opportunities for CAP exempt employment, more so than probably folks in almost any other occupation, right? Accountants looking for CAP exempt opportunities don't have a lot of success. Physicians looking for CAP exempt opportunities tend to be able to find them, but it does take a little bit of extra legwork. And I do recommend, and I recommend this to all international physicians, be upfront with potential employers about your needs. Ask them, are you CAP exempt? The recruiter might not know, and they can go back and find out. Or they might know because their immigration lawyer has been telling them for years, no, you can't hire H-1B you can't hire H-1B doctors because you need to go through the CAP lottery. And, it just is really challenging to do that. So definitely ask recruiters if they know if they're CAP exempt. A lot of times they will, and it's at least good to open that dialogue. One thing that people get confused about is that H-1B folks don't have to work in underserved areas. That is really a J-1 issue. So a physician who is just in H-1B status, never had a J-1, we're not worried about any sort of waiver. Being in an underserved area is totally irrelevant to the H-1B CAP or any other aspect of H-1B sponsorship. And it's really important to know that because some recruiters get confused with that as well, because all they hear about when they go for immigration education is about underserved areas because we talk about J-1s so much. So just know, J-1s are just not, underserved areas are just not relevant to H-1B CAP exemption or any aspects of H-1B sponsorship. All right, so let me take a breath. We talked about a lot of H-1B information, what it is, some basic, critical issues to be aware of, including the H-1B CAP and CAP exemption. And now we're going to switch gears a little bit and talk about, well, what happens if you need to get off of that H-1B? You're hitting the 6-year limit and you haven't started a green card application and, you just don't have time and you need to do something else. You are finishing training and you just cannot find a CAP exempt opportunity in the area you want to live in. There could be any number of issues that come up that cause you to want to seek some other status. Unfortunately, the options are a little limited. There, it's not that there are a million other letters of the alphabet that we can use. Notably, the 3 non-immigrant statuses that just come immediately to mind are O1, E3, and H-1B1. And we'll take E3 and H-1B1 first. We're going to talk more in depth about O's on the next slide. There are some types of immigration statuses, non-immigrant statuses, that are available to only citizens of particular countries. I know that is not a popular topic if you're not from one of those countries, but it's an important thing to know about. So E3s are available at this point only for Australians, and H-1B1s are available to folks from Chile and Singapore. The neat thing is that both of these statuses have a lot of similarities to H-1B status, and there are limits on the number of these visas that can be issued every year, but those limits are never hit. folks can apply directly at the embassy or consulate in their home country for E3 or H-1B1 status. They don't have to apply to USCIS. There's a little bit more flexibility. The prevailing wage requirements do apply. They are approved for shorter periods of time than H-1B, but there's no 6-year limit, right? So there's a lot of pros and cons to the E3 and the H-1B1, but typically if we're working with a physician from one of these 3 countries, we're going to spot that and we're going to be like, why are we doing, especially if there's a cap issue, we're going to be like, why are we doing this for you? We're not putting you through the cap. We're going to go for one of these other statuses. For those of you who might be Canadian or Mexican, you might know about TN status, which is only available to Canadian and Mexican citizens. The challenge with TN status for doctors is that while physicians are on the list of occupations that qualify for TN status, there's a list of like 63 occupations that qualify. It is strictly limited to physicians who engage primarily in teaching or research. Patient care has to only be incidental to that teaching or research to qualify. So if you're, primarily a clinician and you're not really just teaching or engaged in, some kind of bench research or whatever, it could be really challenging for you to get a TN as a physician. It's not something I recommend unless the situation's vetted very closely. So that's TN. So you don't see a lot of physicians on TN status. It's just not really used, but I like to mention it because it is on the list. So if you go Googling it and you're like, why is nobody talking about TNs for doctors? It's because it doesn't really work that well. I don't know why they limited it like that. It's very annoying. Option number 3, in prior years, and this is going back probably to the beginning of my immigration law practice, 15, 16 years ago, we routinely and commonly used physician national interest waiver green card applications as a workaround where somebody was going to run out of time. In those cases, it really worked if we could concurrently file the I-140 and the I-485. The physician may have already completed 5 years in an underserved area during their training, or they sign a prospective contract with an employer for 5 years to work in an underserved area so they can meet the requirements of the PNIW. And then we'd concurrently file it while they were still in training. And back in those days, USCIS was bound to issue EADs, work cards, within 90 days of when we applied. So depending on when we filed that application, we could get a work card before the individual finished residency or fellowship, and they could work on the basis of that work card and never need an H-1B. And then eventually, after they finished the 5 years of service or whatever the background was, they'd get their green card and everybody would be happy. This strategy has become less useful over the years. We're using PNIWs in a different strategic way, for Indian nationals who are backlogged, maybe to get their spouses H-4 EADs, or, to establish early priority dates, or the ability to get those 3-year H-1B extensions. So there's lots of reasons why we might file one of these types of green cards, but we're not filing them concurrently to obtain work cards as an alternative to H-1B so much anymore. Right now, there's a small backlog in the visa bulletin in this category that's preventing us from doing that. But also, we've also become much more reluctant to have our clients in the United States without a valid non-immigrant status underlying that green card. The Trump administration really did away with with folks' desire to assume the risk that everything was going to go swimmingly well with their green card application and the government wasn't going to mess it up. And so, if something gets messed up with the green card and you don't have an H-1B or an O or something underlying that, if it's denied unexpectedly, you could be left in the United States without status. So over the course of the Trump years, we sort of got away from this practice because we didn't want our clients to be without that backup status, that insurance policy, so to speak. But it's still out there as a possible useful option. And in the right circumstances, it could be the right thing, especially where maybe you've done H-1B status, you've finished all 5 years of underserved service during your training. The state that you have worked in will acknowledge that, and we can maybe go file that. Now with premium processing, we can get those I-140s approved pretty quickly. So there may be some, good utility there still, but it's not something we're using quite as often anymore. So let's talk about O1 status. O1 status is probably the most common alternative status that we immigration lawyers use for physicians. We use them not only where folks are, maxing out their H-1B time or need them to get around the H-1B cap, but we also use them sometimes for J-1 doctors who were not able to get waivers before their training ended, and will file an O1 as a workaround, a bridge, until we can get that waiver filed and approved the following year. So O1 has a lot of usefulness for us. Unfortunately, O1s are dependent on the physician having appropriate qualifications, and they're very subjective. So it's important to know, what the basics are and to think critically about whether you would be qualified. And I think having a consultation with an immigration lawyer specifically on your case is really important for O1 sponsorship. So, O1 is an application that is based on a physician having extraordinary ability in their field. The regulations set forth 8 categories of evidence. We have to meet 3 of them comfortably. In other words, we not only need to meet them, but we have to show that by virtue of you meeting those 3 categories of evidence, you are somebody who's at the very top of your field. No publications, having published scholarly articles, that's one criterion. That's not the only one. We're going to look at leadership roles. We're going to look at maybe there's been some press about you. We're going to look at whether you've done peer review or have judged the work of others in your field. We're going to look at what your salary is, the contributions you've made to your field as a whole. Are they major? Have you gotten some accolades for discoveries or techniques that you've pioneered? All kinds of things like that. All of that goes into the O1 petition. They're relatively labor-intensive applications, but in the right circumstances, they can be critical to a physician's ability to continue working in the United States post-training, and even into latter years of fellowship, we've done them. So we file multiple O's for physicians every year as folks, near the end of their training, they find a job. We, realize the immigration is going to be tough, and then we look, okay, is this physician eligible for O sponsorship? A few little key things. You have to have a U.S. employer sponsor. Unlike in the H-1B context, though, independent contractor relationships are okay in the O1 context. If you think about it, we can also use these in the arts, and we do very commonly use these for performers, artists, entertainers, and a lot of times they're sponsored by their agent, not by an employer. And so that kind of relationship is totally fine in the O1 context. In the H-1B context, your employer has to pay all the fees associated with that application. In the O1 context, they may choose to pay for that for you, but they don't have to. And I would say it's a mixed bag in terms of what employers pay for on the O1. There's no prevailing wage requirement here, and the employer's burden in terms of paperwork and compliance documentation is almost non-existent. They're basically signing the forms and providing you with a letter of support, and then they can kind of bow out, right? We're going to take care of the rest. You're going to take care of the rest. And the employer is basically just signing on as the sponsor. So for their perspective, it's a lot easier. For those of you who are familiar with EB-1 green card status, this might all sound very familiar to you because the EB-1 is a self-sponsored green card application based on somebody having extraordinary ability in their field. It is very important to know the Immigration Service itself says in its policy manual that holding H-1B status is not indicative or not having O1 status does not make you automatically eligible for an EB-1 green card. One thing does not equal the other. And in fact, I've seen folks who have O1s get denied for EB-1s. And there have been cases where we've done the O1 for someone and we've said, you know what, we don't think this translates to EB-1. We'd rather do a labor certification based green card for you. So the O, it's its own thing. It doesn't qualify you or make the government required to acknowledge that you're eligible for anything else. So it's important to know that. I see that somebody asked a question about H-4s and H-4 EADs. And that's a really good question because the H-4 EAD also can be an H-1B alternative if your spouse is in H-1B status, if you're running to the end of your H-1B time or need to bridge that, the cap gap, so to speak, switching to H-4 status and maybe applying for an EAD can be a really great option. In order to be eligible for an H-4 EAD, The H-1B spouse has to have an approved I-140 or have been in H-1B status for more than 6 years. So that's the requirement. So the H-4 spouse doesn't have to apply for the green card in order to be eligible for the EAD. It's the H-1B spouse that has to have gotten through those initial milestones to have their H-4 spouse be eligible. But that could be an option. I actually have a client right now. Both spouses had been in H-1B status. Spouse A still is. Spouse B has switched to H-4 and will be getting an EAD. As of the end of January, due to a court settlement, USCIS is now required to adjudicate H-1Bs, H-4s, and the related EADs all at the same time when we file them all together. So where we premium process the H-1B, even though we can't premium process the H-4 and the EAD, we're getting them all together, which is really exciting because it really speeds up the process. But the eligibility requirements for that H-4 EAD still hold. The H-1B needs to have an approved I-140 or be in H-1B status longer than 6 years. That hasn't changed. And there's another question in the Q&A. Do I only work with specific specializations? And the answer is no. Our healthcare group and myself, we work with physicians in all different specialties all around the country, and with other healthcare professionals as well, not just physicians, although physicians do make up the bulk of our healthcare practice. And I like to say we work with folks from Maine to Hawaii and everywhere in between, even Alaska. We pretty much have worked on something, I think, in just about every state at some point over the last 15, 20 years. So it's a pretty wide-ranging practice. Let's see. I think that's it. So we are at the last slide. My contact information is on there, as well as our website address. And I'd like to say that if you go on our website, and there's a place in the upper right-hand corner to schedule a consultation, and we do either 30-minute or hour-long consultations for a fee. There are 2 other attorneys on my team that also work with physicians, in addition to myself, Adam Cohen and Megan Moody. So if you go on to make an appointment and my calendar is like way booked up, definitely look to one of them as an alternative. We all work together in the same office and with the same team behind us. So that's important to know. And so thanks so much for your attention and your questions.
Thank you to Elissa. Thank you so much for your time this evening and for sharing your expertise with all of us. I feel like you are just a brain full of knowledge, and we're so thankful for you. Thank all of you guys for attending as well. I did put the link to the Physician Immigration Handbook in the chat box. So if you haven't had a chance to download that, please take a look in the chat. If you have any more questions that we weren't able to get to tonight, please email Elissa or schedule a consultation appointment through her website. Thank you, everyone, and good night.